Chapter 3, to punish or reform. This picture is a picture of McConnell State Prison in Bevo, Texas. It is a maximum security prison. I was here for a few years. This is where I was a disciplinary investigator and did that for several years. So the goals of sentencing. What is the purpose of sentencing? Well, first of all, you have to know what sentencing is. It's the act of issuing a sanction or a punishment that is imposed by the court according to law. So when someone goes to court and the judge imposes a sanction or a punishment, it then becomes the responsibility of the correctional system to ensure that the judge's orders are being adhered to. So that is the important part of the third category of the criminal justice system, is that corrections is mainly there to impose the sanctions that judges have set forth. As suggested by social scientists, by imposing punishments for violation of the law, offenders are less likely to control or to continue with criminal behavior. This is social order. So when we talk about social order, we have a society that follows norms, that follows laws, that stay within the boundaries of what we see as a functioning world. And when you step out of those bonds, out of that arena, then you disrupt the social order. So when someone commits a crime, they are going out of that social order that we live by. So the goals of sentencing, there are 7 goals of sentencing. They are listed here. Revenge, retribution, just desserts, deterrence, incapacitation, rehabilitation or reform, and restorative justice. So this is what is considered the goal of sentencing. What do we want to see out of sentencing someone or punishing someone for something that they did wrong? Well, revenge is one of them. It's an emotion, an active response to victimization. You feel that you have, especially as a victim, you feel as though you have gotten that revenge on that person so that they are serving time for what they did wrong. It is a consequence to an action that has been committed. Retribution, it's an atonement or payment for the loss suffered by a victim. Retribution, an atonement or a payment. Kind of like revenge, it is something that the victim can see that that person is atoning for their actions. Just desserts. It is the sense of saying that someone is getting what they deserve for the wrongdoing they have committed. Deterrence involves the discouragement of committing a crime. So, for example, what is a good deterrence? When we have an alarm system on our vehicle and the sound of the horn starts going off if someone gets close to your vehicle or touches your vehicle, that is a deterrence. That is something that is hoping that will keep people away from breaking into your vehicle. Same thing for an alarm system for a home. We put signs out in the front of our home that says that you have a certain type of alarm system, or you have a camera system, a surveillance system, to let people know that whatever they are doing, they are being recorded. That is a deterrence. So it's a discouragement from committing a crime. There are two different types of deterrence. There's specific deterrence and general deterrence. And by the way, when we talk about deterrence, we have to talk about um, getting a sanction, getting a punishment. So if someone commits a crime, they're found guilty, they're put on probation, they have to serve probation time. It's um, it's not easy. They have to go out of their way to make sure that they're abiding by their conditions set by the probation. And that hopefully is a deterrent from them recommitting crime, a specific deterrent, punishment to an individual from committing additional crimes, going back and being a recidivist. A general deterrence is a punishment of an individual that is an example to others. Okay, we're going to punish this person and we are going to make an example out of him or her. We see this all the time. Incapacitation, sentencing that removes individuals from society. That means jail time, prison time, or having to serve mandatory substance abuse um, treatment, rehabilitation or reform, sentencing that involves the change of criminal behavior thinking and reintegrates an individual back into society. So when someone is incarcerated, we were talking about the specific programs. So let's say that somebody has been in prison because they have multiple DWIs. So they are going to be put into some kind of substance abuse treatment, counseling that would hopefully deter them or change their behavior from committing crime once again. And then restorative justice is the thinking that restoration should be given to all those affected. For example, the hearing of victim impact statements. This usually happens within the court time. We've seen victim impact statements on TV when they report about crimes where the families of the victims or the victims themselves will be able to address the court and the defendant themselves and let him or her know the damage that has been caused. It helps to give closure to the victim and to their families and let the courts know exactly how they have been impacted. What are we talking about when we talk about sentencing options? Well, the options are available when handing down sentences. While judges are required to sentence within the confines of the law, there are options. There are alternatives to just locking someone up. Now, we started implementing more of these options probably in the late 1990s when mass incarceration was at its highest because of the 1980s war on crime. We started seeing an influx of offenders going into prison. And so we had this mass overcrowding, and we had to decide on what we were going to do. We can't keep putting people in prison and having the people foot the bill for it. We have to start implementing more options. So, what are the options? What are the options of sentencing? Probation is the first option. Can this person be put on probation? Probation, of course, is a conditional release into society that involves restrictions. So we're going to let this person go back out into society instead of putting them in jail. But with probation, we are going to set conditions for them that they must follow. If they don't follow it, then they must go to jail or to prison. So, of course, most people would rather go back out into society than to go into prison. But in order to do that, you have to fulfill those conditions. So, probation is probably the first option. Then there are intermediate sanctions, which is part of probation, but it's harder probation. When you start getting into intermediate sanctions, you start getting into more conditions. It's not just enough to stay out of trouble. You are going to either have fines, you're going to have some type of maybe extensive supervision where you have to be meeting with a probation officer more often. You may have to do drug or alcohol testing, wear an ankle monitor. All that is a part of intermediate sanctions, which just simply means a higher level of probation. Jail or prison time, confinement of someone for a crime committed. So, of course, this is a sentencing option. If probation or intermediate sanctions are not available because either they have been violated or because the crime does not allow for that, then they are sentenced to jail or prison. Uh, then there is the option for parole. Parole is something like probation, uh, but totally different. Probation is usually handled by the county where the crime was committed, whereas parole is handled through the state prison system. And that means that they are released from prison maybe early because of good behavior, or maybe there is a mandatory parole. They have done a certain amount of time, so now they are able to get out on parole. And much like probation, they must answer to a parole officer. They may have some kinds of conditions set on them. So they must abide by those conditions so that they don't get revoked from their parole. And then, of course, the last sentencing option is the death penalty or capital punishment. This only happens on capital offenses, and we will get into that a little bit later. Capital punishment. Let's talk a little bit about the death penalty. This picture that I have is the death chamber in Huntsville, Texas. And the picture below that is Old Sparky. That is the electric chair that was used for many years in the prison system. Probably in the late 70s, I believe, is when they started doing lethal injections. And the electric chair was no longer used in Texas. So, in order to talk about the death penalty properly, we have to look at two major Supreme Court decisions. So, back in 1972, Furman versus Georgia, the death penalty was judged to be arbitrary. It was decided with a majority vote of the Supreme Court that the death penalty, as it was being imposed, was deemed cruel and unusual. It was against the Eighth Amendment, which of course is cruel and unusual punishment. So when we talk about it, we're not saying that the Supreme Court said that the death penalty is cruel and unusual and should not be done. It was deemed arbitrary. It was kind of said that, okay, you've got the death penalty, but you're not using it in the right way. You're not following strict guidelines in order to um, make sure that you're adhering within the Constitution, specifically the Eighth Amendment, which is no cruel and unusual punishment. So in 72, the Supreme Court deemed that it was not being used in the right way. So across the nation, the death penalty was put on hold. Um, Anyone who had been sentenced to death up until that time had a reprieve. In other words, the death penalty no longer was for them. They could not be put to death. I have a fun fact there that Charles Manson and his followers were given the death penalty for the murders of Sharon Tate and her friends and the LaBiancas in 1971. But when Furman versus Georgia came around, all those sentences were commuted to life in prison. So that means everyone in the United States had a death penalty that was commuted to life in prison, and the death penalty no longer applied to them. So that's why this particular court case is extremely important, because it did away with the death penalty until something else could be done. Well, then a few years later, CRIJ versus Georgia, the death penalty was brought back. It was reestablished because there were guidance standards in sentencing. Prior to this, because the Supreme Court had deemed it as arbitrary and not with specific standards, they were seeing that it was very racially charged, and a lot of people of minority were being put to death. So that's when the court said, we need to establish guidelines as far as who can be put to death and who cannot. So that's what was done with CRIJ versus Georgia. There were some guidance standards in sentencing that were done. And then that made it possible for the reissuing of the death penalty. So for those 4 years, there was no death penalty, and everyone who had been sentenced to death prior to that had their sentence commuted to life. After 1976, then the death penalty started to take place once again. So this is very important. Remember these two cases, especially for your test, because they will definitely be on there. So let's talk about a few facts about the death penalty. In order for the death penalty to take place, all the appeals must be exhausted. So when you hear about someone being put to or sent to the death chamber or to death row, they don't have a date that is given right away. It takes years and years of appeal. Inmates can be on death row anywhere from 10 to 25 years, depending on how their appeals work. I do have a video on Anthony Haynes. It does give a story regarding his death penalty sentence, so you may want to watch that. But all appeals must be exhausted first. If there is a wrongful conviction, usually that comes out with appeal, further investigation. If you have incompetent defense, if you can prove that your defense lawyer did not do their job the way that they should have, that could mean that the death penalty can be commuted or you could be retried. Juveniles are excluded from death. So anyone under the age of 18, when they committed a capital offense, does not have the death penalty on the table. With a capital offense, the sentencing is either death or life in prison without parole. That is a capital offense. So with anyone under the age of 18, it would automatically mean imprisonment without the possibility of parole. And then anyone who has a low IQ is excluded from death. I want to say if anyone has an IQ below 73, it excludes them from the death penalty. There are 3 types of sentences that we need to discuss. Consecutive sentences, concurrent sentences, and consolidated sentences. This is when someone has multiple sentences that they are being tried for. So when you have consecutive sentences, those sentences run back to back. And they're considered boxcar sentences. So let's give an example. Let's say, for example, you have someone who was charged with 3 counts of burglary, and each sentence is 7 years long. And the judge decides that they have to do the terms consecutive. That means that on those three burglary charges, they're going to do the 7 years, and then they're going to start over and they're going to do 7 years again, and then they're going to start over and they're going to do 7 years again, because there are three um, charges with 7 years each. So that is consecutive. That happens some of the time. It doesn't happen most of the time. Usually sentences are concurrent and they run together. So let's use the same example. You have 3 counts of burglary, 7 years each. You are going to serve a total of 7 years because they're all going to run together. They're going to run concurrent. And then you have consolidated sentences. Those are multiple charges that are joined together or consolidated for judgment. So they may be it's going to be one sentence for multiple charges, and they're going to be consolidated into one charge. So that's what that means. So know what each one of those means. The most popular one that is used is the concurrent. When we talk about mandatory minimums, we're talking about mandatory sentences for particular crimes. For example, if someone has shoplifted, there would be a mandatory minimum that the judge would need to set. If you go to the link that is provided, it will explain in more detail what the mandatory minimums are all about. What are the different types of sentencing? So there are really two types, an indeterminate and a determinate. In the state of Texas, there is no indeterminate sentencing. But in some states, a judge can sentence someone to a minimum and a maximum. So for a certain crime, judges can sentence from 10 to 20 years. So that means your minimum that you would do would be 10 years. The maximum you would do would be 20 years. And in the state of Texas, we use determinate sentencing. So you will be sentenced to 10 years, to 5 years, to 8 years. There is no minimum and maximum. But within the determinate sentencing, there are three types. There's flat time, mandatory, and presumptive. For flat time, the judges can select between probation and incarceration, but have little discretion in setting the length of the prison sentence because that has already been determined by law. So judges will sentence someone to probation or to a flat time of 5 years, for example. Mandatory is a specified number of years of imprisonment that is provided for each crime. So, for example, if you have an aggravated crime, if you have committed something aggravated like assault with bodily injury, in the state of Texas, you must do half of your time before you are entitled to apply for parole. So, for example, if you have gotten a 20-year sentence for an aggravated crime, that means that you must remain in prison for at least 10 years before you can come up for parole. That doesn't mean that you're going to make parole, but you can apply for parole. In a presumptive, the legislature provides a sentence range, and the judge has to abide by the sentencing. So judges don't have the will to just set any type of prison sentence. For example, if it is a burglary, then the judges have to stay within the confines of the law and not sentence above what the law has allotted for that sentencing. If the judge goes above that number, then they must provide a written reason as to why they have gone outside the range. And of course, that is available for appeal and can be uh, sent up to the appellate court. So know the different types of sentencing. So let's talk about the death penalty. It is a very controversial topic. It's probably somewhere 50-50 as to whether or not people agree or disagree with the death penalty. According to a 2021 Gallup poll, it showed that 54% of Americans believe in the death penalty. So it's about 50-50. There are 5 ways in the United States that the death penalty can be carried out. The lethal injection, and that is for all of the states that participate in the death penalty. Electric chair, firing squad, lethal gas, and hanging. And yes, there are some states that allow for something other than lethal injection. And I put on there which states allow what. In fact, earlier this year, there were 2 inmates in South Carolina who elected to be put to death by firing squad. Now, of course, they have to put in their reasons as to why they want this particular type of death execution. So, but there were 2 people in South Carolina earlier this year that were put to death by firing squad. The states that do not have the death penalty are Minnesota, North Dakota, Wisconsin, Arkansas, Hawaii, West Virginia, Rhode Island, Vermont, Maine, and Massachusetts. So those states do not participate in the death penalty. All states have lethal injection, but like I said, there are a few states that allow for something other than lethal injection. As far as the poll, we talked about 54% of Americans believe in the death penalty. Of the 54% approval, 60% of those are men and less than 50% are women. Sentencing trends and reforms. The First Step Act was signed into law in 2018 during President Trump's first term of presidency. This act reduced sentences of approximately 3,000 offenders. It had to do with the possession of cocaine. Now, these were sentence reforms for federal offenses only. It did not include those state offenses. The Fair Sentencing Act of 2010 was signed in by President Obama, and this reduced mandatory sentencing for first-time drug offenders. And again, this was for federal offenses and not state. And the Tough on Crime Act of the 70s and 80s saw a large number of people sentenced for drug violations. So this is when the mass incarceration started to evolve, was during this time. During the 70s, we did see an increase in crime, and in the 80s, we saw the increase in incarcerations because of the drug reforms that have been done. There have been 6 types of reform within the past 2 decades by some states and the federal government. They have done some modifications to sentencing, probations and parole revocation reforms, the changes in criminal law using jails instead of prisons, opting to use an early release, and juvenile sentencing reforms. So all these types of reforms have helped to decrease the overpopulation of jails. And like I said before, probably beginning in about 2010 is when we started to see a dramatic decrease in jail population, especially here in the state of Texas. At the highest point in Texas, I believe there was something like 175,000 individuals that were incarcerated in state prisons. And we have since reduced that to about 145,000. These are a couple of videos that will explain the First Step Act and the Fair Sentencing Act. I suggest you probably look at those. What are issues in sentencing? There are 5 types of issues in sentencing. When we talk about sentencing, fair sentencing is the term that has become popular in recent years. And in disposing fair sentencing, it must be fair and to both the victim and the offender. So judges have the accountability to be fair in how they sentence, but not only to the victim, but also to the offender. Proportionality, what exactly is that? Well, it is the punishment that has to match the severity of the crime. So, of course, if you have someone who is burglarizing, you're not going to sentence him or her to a sentence that may be for robbery. The sentence, the punishment must fit the crime. Equity, similar crimes and offenders should be equal and not have disparages. So when we talk about race, for example, everyone should be given equal sentences for the crime they have committed. The law should not be sentencing minorities to more years than non-minorities, for example. Individualization, just meaning that each individual who is incarcerated must have individualized treatment. And that's why you have assessments, because the assessments are going to allow authorities to know exactly which programs the offenders need to be in. And that's why you have evidence-based practices, because this is going to show which ones are more effective. And then you have parsimony. These are sentences that should be the least necessary to achieve the same end result. Kind of like equity. You have to make sure that the punishment fits the crime in order to have the best end result.